Welcome to the audio reading of Don't Blow Your DWI DUI Case, Key Mistakes to Avoid. Combs Waterkotte, Missouri's leading DWI DUI law firm, has handled over 10,000 criminal defense cases successfully in the state of Missouri. This ebook guides you through the DWI DUI defense process and helps you avoid key mistakes. Chapter 0, Introduction. Whether you drank more than you thought, made a decision you regret, or somehow got arrested even though you did nothing wrong, being charged with a DUI DWI can be an incredibly stressful and overwhelming experience. The fear of losing your driving privileges, the potential for significant fines, and the possibility of jail time can all weigh heavily on your mind, especially if this is not your first offense. It's a situation that can leave you feeling isolated and unsure of what steps to take next. Combs Waterkotte is Missouri's leading DWI DUI law firm. We've published this ebook to help guide you through the DUI DWI process, minimize the impact on your life, and achieve the best possible outcome in your case. We have successfully handled over 10,000 DWI cases in Missouri, and we can help you. In this ebook, we will cover the most important mistakes to avoid in your DWI case. Assuming you are guilty in a court of law. Understanding the presumption of innocence and why there's always a way to fight your charges. Not hiring a DWI DUI defense attorney right away, and not hiring the right attorney. The importance of securing experienced legal representation immediately. Mishandling the traffic stop. How to conduct yourself during a DWI traffic stop to protect your rights and improve your defense. To blow or not to blow. Breathalyzers, blood tests, and field sobriety tests. Making informed decisions about sobriety tests and understanding their implications. Not understanding your rights and the criminal process. Police aren't perfect either. Knowing your rights and how to ensure they are respected throughout the process. Underestimating the charges and consequences. Recognizing the seriousness of a DWI DUI charge and its long-term financial and lifestyle impacts. Failing to request an administrative hearing. The crucial steps to take to contest your license suspension. Posting about the case on social media. How social media activity can harm your case, and why it's best to stay offline. By applying the knowledge gained from this book, you can strengthen your defense. By not assuming guilt and hiring the right attorney, you ensure that your defense is robust and well prepared. Protect your rights. Understanding the legal process and your rights helps you make decisions in crucial moments. Avoid common pitfalls. You can reduce the risk of self-incrimination and procedural missteps. Mitigate consequences. Requesting an administrative hearing and limiting evidence can help you maintain your driving privileges and minimize the broader impacts on your life. Facing a DWI DUI charge is undeniably daunting, but with the right approach and informed decisions, you can better manage the situation and work towards a more favorable resolution. This book is a tool to empower you through this difficult time, providing actionable steps to protect your future. Remember, while this book offers comprehensive advice, it is not a substitute for personalized legal counsel. Always consult with an experienced DWI/DUI defense attorney to tailor strategies to your specific case. By doing so, you can navigate the legal complexities with confidence and competence, striving for the best possible outcome. Chapter 1. Assuming you are guilty in a court of law. Getting pulled over and arrested for a DWI DUI can be nerve-wracking, and feelings of guilt and embarrassment, along with the daunting possibility of months of court battles, makes many DWI DUI suspects think they should plead guilty. While there may be some cases in which a plea deal, plea of no contest, or reduction of charges offer your most favorable outcome, you are still presumed innocent until you plead guilty or are convicted. With the aid of an experienced DWI/DUI defense lawyer, beating a drunk driving charge is not nearly as impossible as many people think. Assuming guilt prematurely can lead to unnecessary self-incrimination and poor decision-making, such as hastily accepting a plea deal without fully understanding the potential defenses available. Not pleading guilty immediately is your best option, regardless of whether or not you were over the legal limit. If you were not over the legal limit but failed a test, the legitimacy of those tests and the traffic stop can be challenged by an experienced DWI/DUI defense attorney. If you actually did drive under the influence or while intoxicated, the same principles apply to your DUI case as any criminal case in the United States. You have the presumption of innocence and a right to present a defense in court. The state cannot convict you if it cannot prove you were driving while intoxicated with legitimate evidence. Common reasons for pleading guilty to a DWI/DUI charge, and why not to. There are a variety of scenarios in which one might think their best option is to plead guilty, but that is typically not the case. Let's go over a few common reasons and why it's a bad idea. Belief in inevitable conviction. Reason for pleading guilty. You might want to plead guilty because you believe the evidence against you is overwhelming and that a conviction is inevitable. You might think that by pleading guilty, they can avoid the stress and expense of a trial and possibly receive a lighter sentence. Let's talk about why it's a bad idea. You ignored a possible defense. Pleading guilty means forfeiting the opportunity to explore possible defenses. There may be procedural errors or issues with the evidence that a skilled attorney could use to your advantage. For example, improper calibration of a breathalyzer or mishandling of blood samples can lead to evidence being thrown out. Severe penalties. Even with a guilty plea, the penalties can be severe, including fines, jail time, and long-term impacts on your driving privileges and criminal record. Don't assume the court will treat you better if you plead guilty. An attorney can negotiate on your behalf for a lighter sentence or a complete dismissal. Permanent record. A guilty plea results in a criminal record that can affect future employment opportunities, professional licenses, and other aspects of your life. Pressure or misinformation from law enforcement. Reason for pleading. Guilty. Law enforcement officers or prosecutors may pressure individuals to plead guilty by emphasizing the strength of their case or the potential consequences of going to trial. Let's talk about why it's a bad idea. Coercion and misinformation. Law enforcement's job isn't to look out for your future. It's to get a conviction as quickly as possible. While you have a right to remain silent and a right to an attorney, police are legally allowed to lie to you to elicit a confession. Pleading guilty under pressure can lead to decisions based on fear rather than a careful consideration of the facts. Law enforcement and prosecutors may overstate the likelihood of conviction or the severity of potential penalties. Right to a fair trial. Everyone has the right to a fair trial where the prosecution must prove their case beyond a reasonable doubt. By pleading guilty, you waive this fundamental right and the opportunity to challenge the evidence and cross-examine witnesses like the arresting officer. Potential for reduced charges or dismissal. Through a rigorous defense, there is always the possibility of reduced charges or even a complete dismissal of the case if procedural errors or weaknesses in the prosecution's case are identified. Financial concerns. Reason for pleading guilty. The cost of legal representation and the prospect of a prolonged legal battle may lead some individuals to plead guilty to avoid additional expenses. Let's talk about why it's a bad idea. Hidden costs. While pleading guilty might seem like a way to save money by avoiding hiring a lawyer, the long-term costs can be significant. Increased insurance premiums, fines, and the potential loss of income due to license suspension or job loss can far exceed the costs of mounting a defense. Impact on future earnings. A DWI or DUI conviction can impact future employment opportunities, professional licenses, and earning potential. The financial implications of a conviction can be long-lasting and substantial. Access to legal aid. In many cases, individuals may qualify for legal aid or pro bono representation, which can help mitigate the financial burden of a defense. While a public defender may not have the experience or time to mount an effective DWI/DUI defense, exploring these options can provide quality legal representation without prohibitive costs, avoiding the hassle. Reason for pleading guilty. Often, individuals will plead guilty to a DWI/DUI charge because they want to avoid the hassle and stress of a prolonged legal battle. They may perceive the court process as intimidating and time-consuming, and believe that pleading guilty will allow them to quickly put the incident behind them and move on with their lives. Why it's a bad idea. Long-term consequences outweigh short-term convenience. Pleading guilty to avoid the immediate hassle may seem appealing, but the long-term consequences of a DWI/DUI conviction are far more burdensome. These consequences can include substantial fines, mandatory alcohol education or treatment programs, license suspension, increased insurance premiums, and even jail time. Permanent criminal record. A guilty plea results in a criminal record that can affect many aspects of your life, including your ability to secure housing, maintain employment, and maintain professional licenses. While many DWI/DUI convictions can be expunged if certain requirements are met, the criminal record can follow you for years, impacting your reputation and limiting your opportunities. Underestimating the legal process. The belief that pleading guilty will streamline the process is often misguided. Even with a guilty plea, there are still legal procedures and requirements that must be fulfilled. You will still need to attend court hearings, comply with sentencing requirements, and manage the financial and personal repercussions of the conviction. The presumption of innocence in DWI/DUI cases. Scenario: you failed the test and blew over the limit. However, the state still has to prove their case beyond a reasonable doubt. The presumption of innocence ensures that the state must provide compelling evidence and meet a high standard of proof before a person can be deprived of their liberty or subjected to legal penalties. Generally, in a DWI/DUI case, that means the state must prove two things. Impairment. The state must prove that you were impaired by alcohol or drugs at the time of driving. This often involves evidence from field sobriety tests, breathalyzer results, or blood tests. However, these pieces of evidence can be contested for accuracy and procedural correctness. Probable cause for the stop. The initial traffic stop must be lawful, meaning the officer had a valid reason to pull you over, such as observing a traffic violation or receiving a tip about erratic driving. Experienced DWI/DUI defense attorneys will question the reliability of breathalyzer tests, the conditions under which field sobriety tests were conducted, and the handling of blood or urine samples. They can also scrutinize the legality of the traffic stop and the procedures followed by law enforcement. Evidence in a DWI/DUI case and how to challenge it. While the evidence may seem stacked against you, that evidence is not as airtight as law enforcement may have you believe. Here's a look at the key types of evidence and their implications in Missouri DWI/DUI cases. Types of evidence in DWI/DUI cases. Field sobriety tests, FSTs. Description: these are physical and cognitive tests conducted roadside to assess a driver's impairment. Common FSTs include the horizontal gaze, nystagmus, HGN, walk and turn, and one-leg stand tests. Challenges. FSTs are highly subjective and can be influenced by factors such as the suspect's physical condition, weather conditions, and the officer's instructions. Challenging the administration and interpretation of these tests can be a key defense strategy. Breathalyzer tests. Description. Breathalyzers measure blood alcohol content, BAC, through a breath sample. Missouri uses both portable breathalyzers at the roadside and more accurate machines at the police station. Challenges. The accuracy of breathalyzers can be questioned based on calibration, maintenance records, and the presence of substances in the mouth that might affect results. Additionally, certain medical conditions can produce false positives. Blood and urine tests. Description. These tests provide a more direct measure of BAC or the presence of drugs. Blood tests are typically more accurate than breath tests, but require a warrant if the suspect refuses. We'll explain why you should refuse in a later chapter. Challenges. Potential errors include contamination, improper storage, and procedural mistakes in the chain of custody. Timing of the test relative to when the person was driving is also a critical factor. Officer observations. Description. These include the officer's observations of the driver's behavior, speech, appearance, and driving pattern. Challenges. Subjective observations can be contested based on the officer's experience, environmental conditions, and the presence of other factors that could explain the behavior, e.g., fatigue, stress. Dash cam and body cam footage. Description. Video evidence from the officer's dash cam or body cam can provide a real-time account of the traffic stop and the suspect's behavior. Challenges. Video footage can be used to corroborate or dispute the officer's written report. It can also show if proper procedures were followed during the stop and arrest. Challenging the evidence in a DWI/DUI case. There are numerous ways a skilled DWI/DUI defense attorney can challenge evidence, preventing it from being used against you in court or persuading a jury that it's unreliable. Procedural errors. Any deviation from standard procedures during the traffic stop, arrest, or testing can be grounds to suppress evidence. This includes improper administration of FSTs, failure to follow protocols for breathalyzer calibration, and violations of the suspect's rights, e.g., not being read Miranda rights. Reliability issues. Questioning the accuracy and reliability of the tests conducted is another key strategy. For example, calibration logs for breathalyzers, contamination risks for blood samples, and the potential for environmental or health factors affecting FST results can all be used to cast doubt on the prosecution's evidence. Expert testimony. Engaging experts in toxicology, forensic science, and law enforcement procedures can provide critical insights and bolster the defense. Experts can explain complex scientific issues in a way that is understandable to a judge or jury, highlighting potential flaws in the prosecution's evidence. Hire a DWI/DUI defense attorney instead of pleading guilty. While pleading guilty to a DWI/DUI charge might seem like an inevitability or a way to quickly resolve the situation, it often leads to far-reaching negative consequences that can impact your life for years to come. The short-term convenience is outweighed by the long-term penalties and missed opportunities for defense. Engaging with the legal process, understanding your rights, and working with an experienced attorney can provide a better chance of minimizing the impact of the charges and securing a more favorable outcome. Chapter 2. Not hiring a DWI/DUI attorney. Right away, facing a DWI or DUI charge can be overwhelming and frightening. One of the most critical decisions you'll make in this scenario is whether or not to hire an attorney to represent you. While some individuals may consider handling their case on their own or even holding off on hiring an attorney, Delaying your decision can have massive repercussions on your future. Don't make the mistake of doing this alone. The following is what tends to happen when you don't hire an attorney, or you hire the wrong DWI/DUI attorney. What happens when you don't hire a DWI/DUI attorney right away? Increased risk of severe penalties. Without an experienced DWI/DUI attorney by your side, you may face harsher penalties than you would with an experienced defense lawyer in your corner. These could include fines. Courts impose hefty fines for DWI/DUI convictions, and without an attorney to negotiate on your behalf, you could end up paying the maximum amount allowable by law, especially if it's not your first offense. Jail/prison time. First-time offenders can face possible jail time, but repeat offenders are at a higher risk of jail and/or prison sentences. A DWI attorney can help reduce or eliminate jail time. License suspension. A DWI/DUI conviction can lead to the suspension or revocation of your driving privileges. As we'll discuss in a later chapter, a lawyer might be able to secure a restricted driving privilege, or even challenge the suspension. Missed opportunities for case dismissal or reduction in lack of negotiating skills. An experienced DWI/DUI defense attorney can identify weaknesses in the prosecution's case that you might otherwise miss. These may include challenging the traffic stop itself. If the law enforcement officer lacked probable cause for the stop in the first place, you might be surprised to learn that your case could possibly be dismissed. Questioning the sobriety tests. Field sobriety tests and breathalyzer results are not infallible. Our experts can challenge the accuracy and administration of these tests. Negotiating plea deals. DWI/DUI attorneys can negotiate plea deals that reduce charges or penalties, or even get you into a diversion program, something extremely difficult to achieve on your own. Lack of knowledge about legal procedures. Navigating the legal system is difficult, especially in the DWI/DUI realm and for those unfamiliar with it. Defense lawyers understand the procedures, deadlines, and necessary paperwork involved in a DWI/DUI case. Without access to this knowledge, you risk improper filing. Incorrectly filed documents can delay your case, putting you at a significant disadvantage, essentially fighting an uphill battle from day one for a seemingly inconsequential mistake. Missing deadlines. Failure to meet court deadlines can result in additional fines, stricter penalties, or even an automatic guilty verdict. Needless to say, you need a trustworthy DWI/DUI attorney on your side. Risk of harsher long-term consequences. A DWI/DUI conviction can have long-lasting effects on your life, including employment. Many employers conduct thorough background checks, and a conviction can have a negative impact on future employment, or could even result in the loss of your current job. Insurance rates. A DWI/DUI conviction typically leads to higher insurance premiums and requires you to file an SR-22. Permanent record. A conviction will stay on your criminal record, potentially affecting future legal matters and opportunities. Increased stress and anxiety. In addition to the previously stated overwhelming and frightening feelings, facing a DWI/DUI charge is stressful. Handling it alone can boost this anxiety. Without a skilled DWI/DUI attorney, you'll need to manage, gathering evidence. You'll need to collect and present compelling evidence, including witness statements and expert testimonies. This takes time and expertise that our lawyers already possess. Court appearances. You will need to represent yourself in court. This may seem simple, but trust us, it's not. It is intimidating. Cross-examination. Cross-examining police officers and any other witnesses without extensive legal training can be daunting, ineffective, and can actually have an adverse effect. Imagine questioning the same officer who pulled you over. Let's talk about the importance of hiring the right attorney for your DWI/DUI case. While the above describes what happens when you don't have an attorney, by hiring the Waterkotte DWI/DUI legal team, you will get 24/7 availability, as well as talented, tenacious lawyers who will protect your rights and challenge evidence. From the moment you're taken into custody to the conclusion of your case, we will make sure that law enforcement followed proper procedures during the traffic stop and arrest. Challenge any evidence, field sobriety test, breathalyzer, blood or urine samples. Advocate for fair treatment in court. Minimize penalties and consequence. While lawyers at many other law firms may jump at the first plea deal offered, the Waterkotte DWI/DUI attorneys aren't afraid to go to trial. We have a strong record of getting not guilty verdicts. We can also advocate for alternative sentencing options, secure reduced charges or penalties, help you get a hardship license, called a limited driving privilege, letting you continue driving for work, school, and other essential purposes. Develop a strong defense strategy. The right attorney will analyze the specifics of your case, identify weaknesses in the prosecution's evidence, and develop a tailored defense strategy. This may include questioning the validity of field sobriety tests, investigating whether proper protocols were followed during your arrest, challenging the accuracy of breathalyzer or blood-urine test results, presenting evidence of any medical conditions or other factors that could have affected your test results. Hiring the right DWI/DUI attorney immediately after being charged is essential for protecting your rights and minimizing the impact of the charges. An attorney experienced in DWI/DUI claims can navigate the complexities of the legal system, challenge any evidence against you, and work to secure the best possible outcome for your case. Don't risk your future by delaying this important decision. Chapter 3. Mishandling the traffic stop. For both law enforcement officers and drivers, being pulled over on suspicion of drunk driving or other traffic violations can quickly escalate from a routine check to a dangerous situation. It's essential to stay calm and avoid saying or admitting to anything that could incriminate you. Every traffic stop is unique, and remaining composed can prevent unnecessary complications even if you're innocent of any wrongdoing. What to do? If you're stopped by the police for suspected DWI/DUI, taking the right steps during the traffic stop can limit the state's evidence against you and greatly improve your chances of getting the best possible outcome in your case. Step 1. Stay calm and composed. The first and most crucial step is to remain calm and composed. Anxiety and panic can lead to erratic behavior, which may raise suspicion and give law enforcement more reasons to investigate further. Take a deep breath, keep your hands visible, and comply with the officer's instructions unless the officer is requesting a sobriety test. Step 2. Keep hands visible. Place your hands on the steering wheel where the officer can see them. This helps to ensure the officer feels safe and can approach your vehicle without heightened concern. Avoid sudden movements. Sudden movements can be perceived as a threat. If you need to reach for something, such as your license or registration, inform the officer before doing so. Step 3. Be polite and respectful. Interacting with the officer in a polite and respectful manner can positively influence the encounter. Aggressive or disrespectful behavior can escalate the situation and lead to additional charges, such as resisting arrest or disorderly conduct. Remember, often the officer will have dash cam video from their car and will likely be wearing a body cam. Step 4. Address the officer respectfully. Use polite language and address the officer as officer. This demonstrates cooperation and respect. Step 5. Follow instructions. comply with the officer's requests, such as providing your license, registration, and proof of insurance. Failure to do so can result in additional legal complications. We'll discuss why not to submit to sobriety tests in the next chapter. Step 6. Know your rights. It's important to understand and exercise your rights during the traffic stop. While cooperation is important, you are not obligated to provide information that could incriminate you. Step 7. Right to remain silent. You have the right to remain silent. You are not required to answer questions about where you are coming from, where you are going, or whether you have been drinking. Politely inform the officer that you are exercising your right to remain silent. Step 8. Right to refuse consent to a search. Unless the officer has probable cause or a warrant, you have the right to refuse a search of your vehicle. Clearly and politely state that you do not consent to a search. Step 9. Avoid self-incrimination. One of the most common mistakes during a traffic stop is providing information that can be used against you. Be mindful of what you say and avoid volunteering unnecessary information. Step 10. Do not admit to drinking. If asked if you have been drinking, you are not required to answer. Admitting to drinking can provide the officer with probable cause to conduct further tests. Step 11. Limit conversations. Keep your responses brief and to the point. Avoid engaging in casual conversation or making statements that could be misconstrued. Step 12. Request an attorney. If you are arrested or if the situation escalates, clearly and calmly request an attorney. Having legal representation can help protect your rights and ensure that you are treated fairly. Step 13. Invoke your right to an attorney. Clearly state, "I would like to speak to an attorney." Repeating this request can be important if the officer continues to question you. Step 14. Do not answer questions. Without legal counsel. Once you have requested an attorney, refrain from answering any further questions until you have legal representation. The second a traffic stop turns into a DWI investigation, the best approach is to remain silent, avoid answering incriminating questions, allow law enforcement to take you into custody if they believe you are under the influence, and contact a DWI defense lawyer immediately. What not to do if you're pulled over. If you've been drinking and are pulled over for speeding, swerving, or other traffic violations, keep the following in mind. Do not argue with the officer. Arguing or being confrontational can escalate the situation. Stay calm and respectful, and save any disputes for the courtroom. Do not reach for anything. Avoid reaching for your license, registration, or any other items until the officer asks you to do so. Sudden movements can be perceived as a threat. Do not exit the vehicle. Unless instructed by the officer, stay in your vehicle. Getting out without being asked can be seen as aggressive or threatening behavior. Do not lie or give false information. Providing false information to a law enforcement officer is illegal and can lead to additional charges. Do not refuse to provide documentation. When asked, you must provide your driver's license, registration, and proof of insurance. Refusing to do so can result in further legal consequences. Police are restricted in the evidence they can gather without a warrant, which is crucial for protecting your rights. An experienced DWI/DUI attorney can challenge the legality of evidence obtained without proper authorization, potentially leading to reduced charges, dismissal, or a not guilty verdict. Chapter 4. To blow or not to blow during a DWI traffic stop. Getting pulled over for a suspected DWI can be intimidating, regardless of whether or not you've been drinking. In the last chapter, we discussed the importance of remaining calm and remaining silent during the traffic stop. In this chapter, We will explore the various tests law enforcement may ask you to perform and why we advise against submitting to them. Why refuse sobriety tests? We advise against submitting to a breathalyzer, field sobriety tests, or other tests for the same reason you should remain silent. By submitting to these tests, you are giving law enforcement more evidence to use against you. The main reasons for refusing are: 1. Keep law enforcement from acquiring additional evidence against you too. Reduce the state's evidence to simply the arresting officer's judgment. You may ask, won't my license get suspended if I refuse sobriety tests? Possibly, and without the aid of an experienced DWI defense lawyer. Almost certainly. Under Missouri Revised Statute Section 577.020, refusing a test, with the exception of a portable breath test, from an officer who had reasonable grounds to believe you were operating a vehicle or vessel while in an intoxicated condition, will lead to a license suspension of 1 year. This is known as chemical revocation. Driving in Missouri and throughout the United States is considered a privilege, not a right. All U.S. states operate under the principle of implied consent. Implied consent is the legal principle that by applying for a license and driving on public roads, drivers automatically agree to submit to chemical tests for alcohol or drugs if suspected of driving under the influence. From the state's point of view, if you refuse the tests, you are breaking your agreement, so they have the right to withdraw your driving privileges. Still, our Missouri DWI/DUI defense attorneys recommend not submitting to any tests. In most cases, a capable DWI defense attorney will be able to keep your license from being suspended because of a chemical revocation. Without the added evidence of breath, blood, urine, and field sobriety tests, your case may become a simple license suspension revocation case instead of a full-fledged DWI/DUI case. You may ask, won't I get arrested and charged if I refuse sobriety tests? It's a possibility, but that's almost always true if you submit to the tests. It is much easier to fight against a DWI/DUI charge, or even have it dismissed or the charges reduced, without the added evidence from the tests. Waterkotte's defense attorneys recommend simply telling the officer they can take you into custody immediately after the traffic stop turns into a DWI/DUI investigation. Most first-time offenders will be released 8 to 12 hours after they are detained. If you follow our advice and contact an experienced DWI/DUI attorney while in custody, they will have already started building your defense. Now, let's look at each type of sobriety test and why you should refuse them. Field sobriety tests. Field sobriety tests, or FSTs, are often used by law enforcement to assess a driver's level of impairment. These tests include horizontal gaze nystagmus, HGN, observing the eyes to look for jerking movements. Walk and turn, walking in a straight line and turning on one foot. One leg stand, standing on one leg for a certain period. These tests are highly subjective and can be influenced by various factors such as nerves, being pulled over, speaking to law enforcement, and being asked to perform sobriety tests can be nerve-wracking and intimidating, affecting your performance. Medical conditions. Conditions like vertigo, inner ear problems, or even being overweight can impact balance and coordination. Environmental factors. Uneven surfaces, poor lighting, and weather conditions can affect test performance. Again, while officers are trained to conduct the tests, these tests are highly subjective and open to interpretation. An officer's bias or misunderstanding can lead to incorrect assessments of your sobriety. FSTs are even often failed by people who haven't had anything to drink. Even if you perform well, the officer's interpretation of your performance can be biased and used against you. Because courts value law enforcement testimony highly, your best bet is to simply not provide the state with additional evidence against you. Let's talk a bit about breathalyzers. There are two types of breath tests. Portable breathalyzers, PBT. These are used on the scene and are less reliable. Refusing this test will not lead to a chemical revocation. Stationary breathalyzers, administered at the police station and are considered more accurate. Refusing this test will lead to a chemical revocation. Refusing a breathalyzer test means the state will have to rely solely on the officer's observations and your behavior at the scene, which can be easier to challenge in court. The main reasons to refuse: technical reliability. The variability in the device's accuracy means that you could be unfairly charged for an incorrect reading. Evidence reduction. By not providing a BAC reading, you limit the quantitative evidence that can be used against you, making it harder for the prosecution to prove their case beyond reasonable doubt. Blood and urine tests. If you are taken into custody and refuse a breath test at the station, police will ask you to submit to a blood and/or urine test to determine your BAC. The U.S. Supreme Court has ruled that obtaining a blood or urine sample is a form of a search under the Fourth Amendment. That means that police must either obtain your consent or a warrant to legally collect a sample. If you refuse and they obtain a warrant, police are allowed to use reasonable force to get a sample, even by using a catheter to collect urine. Therefore, up until the time you are presented with a warrant, you should refuse all tests with the same goal of limiting the state's evidence against you. Here are a few other reasons why. Warrant requirement. If the police obtain a warrant, it ensures they have followed proper legal procedures. This process requires the officer to demonstrate probable cause to a judge, which can provide additional grounds for your defense if the warrant was improperly issued. While probable cause is necessary for many law enforcement actions, the requirement for a warrant adds an extra layer of judicial oversight, specifically for blood and urine tests. Chain of custody. Proper chain of custody must be maintained from the time the sample is taken to the time it is analyzed. Any break in this chain can be used to challenge the validity of the evidence. This meticulous documentation process provides multiple opportunities for defense attorneys to find errors or lapses. Testing errors. Laboratory errors, such as improper procedures or equipment malfunctions, can lead to inaccurate results. Improper handling or storage of samples can lead to contamination and inaccurate results. Contaminated samples can produce false positives or exaggerated BAC levels. Test timing. The timing of the test in relation to your last drink can significantly impact BAC levels. As your body processes alcohol, BAC levels rise and fall, and a delayed test may not accurately reflect your BAC at the time you were driving. This delay can be advantageous for your defense. Rising BAC defense. As your body processes your last drink or two, your BAC levels will continue to rise even after you've stopped drinking. This means if a blood test, performed at the station after a warrant, reveals that your BAC was over 0.08%, your defense attorney may be able to argue that it was below 0.08% at the time you were driving. This defense hinges on the natural metabolic processes of alcohol in your body. Refusing these tests until a warrant is obtained forces law enforcement to adhere strictly to legal protocols, providing your defense attorney with more opportunities to identify procedural mistakes that could benefit your case. Refusing breathalyzers, blood tests, urine tests, and field sobriety tests is a strategic decision to protect yourself from providing additional evidence that could be used against you in a DWI/DUI case. While this approach may lead to temporary consequences, such as a license suspension, the absence of test results can significantly weaken the prosecution's case. and a license suspension is much easier to beat than a DWI/DUI charge. Seeking the counsel of a defense lawyer who specializes in DWI/DUI charges as soon as possible will allow you to mitigate any consequences of refusing the tests. Chapter 5. Not understanding your rights. Facing charges of DWI or DUI is challenging enough. Don't amplify or exasperate your situation by being unfamiliar with your rights and the criminal process. Understanding your legal rights and the steps involved in a DWI/DUI case is essential for protecting yourself and your future. To safeguard your rights and ensure the best possible outcome for your DWI/DUI charge, it is crucial to consult with an experienced DWI/DUI attorney who can guide you through the legal process and build a strong defense on your behalf. Here's what happens when you don't understand your rights and the criminal process. Understanding your rights and the criminal process is essential when facing a DWI/DUI charge. Without this knowledge or without a skilled and tenacious DWI defense attorney, you risk a multitude of factors, including you could be waiving your rights unintentionally. One of the most significant risks of not understanding your rights, especially if you're going it alone without a DWI/DUI defense attorney, is unintentionally waiving them. These key rights include your right to remain silent. Under the Fifth Amendment, you have the right to remain silent to protect yourself against self-incrimination. Anything you say to law enforcement can be used against you in court. Your right to legal representation. Under the Sixth Amendment, you have the right to consult with an attorney before speaking to the police and at any time during the legal process. Your right to a fair trial. Another protection under the Sixth Amendment. You are entitled to a fair trial, which includes the right to challenge evidence and cross-examine witnesses. Without fully understanding these rights, you may inadvertently provide information or consent to procedures that could harm your defense. As always, the Waterkotte DWI/DUI legal team is available to discuss the specifics of your case. Blindly navigating the court system. The court system is complex, particularly when facing DWI/DUI charges, and procedural mistakes can have serious consequences. Not understanding the criminal process can lead to improper plea bargaining. Without a skilled DWI attorney, you may not be aware of the best strategies for negotiating a plea deal with the prosecution or understanding the long-term implications of different plea agreements. Missed deadlines. Failing to meet filing deadlines or court appearances just screams unprepared and disrespectful to a judge or other court official, and could result in additional penalties or even an automatic guilty verdict. Inadequate defense strategies. Preparing a robust defense requires the ability to grasp complex legal procedures, evidence gathering, and courtroom protocol. Without this knowledge, you're essentially rolling the dice. Your defense may be weak and ineffective. An inability to challenge evidence. A lack of knowledge about the DWI/DUI criminal process can prevent you from effectively challenging the evidence against you. For example, faulty sobriety tests. Field sobriety tests are objective, and breathalyzer results can be flawed. After all, police officers are people. They are fallible. Understanding how these tests should be administered and their limitations is crucial for challenging their accuracy. Improper traffic stop. If law enforcement did not have a valid reason to stop your vehicle, any evidence obtained during the stop may be inadmissible in court. An experienced DWI attorney can build a strong defense strategy based on this error. Chain of custody issues. Any errors in the handling and storage of urine or blood samples can compromise their integrity and potentially lead to the exclusion of this evidence. Creating increased stress and anxiety. Facing a DWI/DUI charge without understanding exactly what is going on and why can significantly increase your stress and anxiety. This can seriously affect your ability to make reasonable, informed decisions. High-stress situations can cloud your judgment, leading to poor decision-making that could negatively impact your case. Manage your daily life. The stress of navigating the legal system, especially solo, can affect your personal and professional life, leading to additional complications and pressures. Hiring the right DWI attorney to help you understand your rights and the criminal process is vital when facing charges. A knowledgeable DWI attorney can help you not waive critical rights, challenge evidence efficiently, and properly navigate the complexities of the legal system. Chapter 6. Underestimating DUI charges and consequences. Driving under the influence, or DUI for short, or driving while intoxicated, DWI, is a serious offense in Missouri, yet many individuals underestimate the gravity of these charges and their long-term consequences. Whether it's the misconception that first-time offenses aren't a big issue, or the lack of awareness about the cascading effects on your personal and professional status, underestimating a DUI charge can lead to major negative outcomes. Understanding the full scope of legal, financial, and personal repercussions is crucial for anyone facing a DUI/DWI charge. Let's talk about the consequences and implications for DUI/DWI convictions. We will now list a quick rundown of why DUI and DWI charges should be taken seriously. Criminal record, impacting employment opportunities and professional licenses. Financial costs, including fines, legal fees, and increased insurance premiums. Mandatory participation in drug/alcohol treatment programs. Social stigma affecting personal relationships and reputation. Potential emotional distress and related health impacts. Potential job loss or limitations on career opportunities. Long-term impact on driving privileges and professional licenses. What happens if I get a DUI/DWI? The consequences of a DUI/DWI go beyond immediate legal penalties. Convictions can result in a criminal record, which can affect employment opportunities, professional licenses, and even housing applications. Financially, beyond fines and legal fees, you may face increased insurance premiums and the cost of mandatory programs and devices. Socially, the stigma of a DUI/DWI can strain personal relationships and impact your reputation. Additionally, the emotional stress and anxiety associated with legal proceedings and potential jail time can have lasting effects on mental health. Understanding these far-reaching consequences is essential for recognizing the seriousness of DUI/DWI charges. It's important to take these charges seriously. Not only can you have points added on your license, you could face jail time, lose your job, and have your license suspended on top of other fines up to $500. Moreover, the impact on your personal and professional life can be profound, affecting your social standing, job prospects, and overall quality of life. The stigma associated with a DUI/DWI can lead to strained relationships, difficulty in securing employment, and even issues with travel, as some countries restrict entry to individuals with criminal records. What if this is my first DUI/DWI? If you were just arrested for or charged with a DUI/DWI in Missouri, Missouri law is clear about the severity of the charge. You can get up to 8 points added to your driving record, up to 6 months in jail, a fine up to $500, a 3-month license suspension, and automatically be enrolled in drug-alcohol treatment programs. A first offense is usually classified as a Class B misdemeanor. You may be wondering, what if this isn't my first DUI/DWI? If you're pulled over for suspicious driving or intoxication, you'll likely be facing a Class A misdemeanor. Keep listening, to hear about some of the potential consequences. Jail time. You may be sentenced to no more than 1 year in jail. Any jail sentence for a second DWI must include a minimum of 10 days of shock time before possible suspension of sentence or probation. Probation. You may be placed on probation for up to 2 years. Fines. Fines can be as high as $1,000. If you're involved in an accident, you may have to pay restitution to anyone who was injured. Special damages cover quantifiable expenses, such as medical bills, lost wages, and property damage. General damages compensate for non-economic losses, including pain and suffering, emotional distress, and loss of enjoyment of life. Driving privileges. Your driving privileges may be suspended for 1 to 5 years. Breath alcohol ignition. Interlock device, BAID. In Missouri, you are required to install and maintain a BAID at your own expense, which prevents the vehicle from starting if your BAC is over a certain limit. Alcohol monitoring. Continuous, verifiable alcohol monitoring is required, either by regular breath tests or a wearable device. Treatment program. Participation in a drug, or alcohol treatment program is mandatory. High-risk auto insurance, SR 22. You must purchase a high-risk auto insurance plan if you want to drive. In the next chapter, we'll discuss the administrative component in a St. Louis DWI case relates to your driving privileges and how the Missouri Department of Revenue handles your license revocation or suspension. Aside from legal consequences, a DUI/DWI can have long-term impacts on various aspects of your life. For instance, if your job requires you to drive, a suspended license can jeopardize your employment. Even if driving isn't a core part of your job, some employers may view a DUI/DWI as a sign of irresponsibility, potentially affecting your career advancement. Furthermore, if you hold any professional licenses, a DUI/DWI conviction could result in disciplinary action or even revocation of your license, depending on your profession's regulations. It's important to seek out legal assistance as soon as possible to mitigate these consequences. Finding an attorney that is willing to challenge the evidence and help you a case is absolutely paramount in order to forego any major lifelong implications. Chapter 7. Failing to request. An administrative hearing. A DUI/DWI charge is 2 cases in one, a criminal case and your license suspension case. If you refused sobriety tests, your license will automatically be suspended for 1 year in a chemical revocation. If you did submit to sobriety tests, you'll face, for a first DUI/DWI offense, a 30-day license suspension followed by a 60-day restricted license. For a second DUI/DWI offense, a 5-year license revocation and a minimum 6 months with an ignition interlock device. For a third DUI/DWI offense, a 10-year license revocation and a minimum 6 months with an ignition interlock device. In either case, under Missouri Revised Statute Section 302.530, you are allowed to challenge the license suspension through an administrative hearing. In Bell v. Burson, the U.S. Supreme Court ruled that, because driving is considered a privilege and not a right, for years there were few effective ways to challenge the suspension of someone accused of a DUI or DWI. In Bell, the Supreme Court recognized that a license's continued possession may become essential in the pursuit of a livelihood. In such cases, the licenses are not to be taken away without that procedural due process required by the 14th Amendment. What is an administrative hearing? An administrative hearing is a separate legal proceeding from the criminal DUI/DWI case, designed specifically to address the status of your driving privileges following a DUI/DWI arrest. In Missouri, when you are arrested for a DUI/DWI, The Department of Revenue is authorized to automatically suspend or revoke your driver's license. You must request the hearing within 15 days of receiving the notice of suspension or revocation. An administrative hearing provides a separate legal avenue to challenge the evidence against you, such as the validity of the traffic stop, the accuracy of sobriety tests, and procedural correctness. The purpose of the administrative hearing is to review the circumstances surrounding your arrest and determine whether the suspension or revocation of your license is justified. This hearing focuses on the procedural and evidentiary aspects of the case, rather than the criminal guilt or innocence typically addressed in court. Key points examined during the hearing include probable cause. Whether the arresting officer had probable cause to believe you were driving under the influence. This involves evaluating the officer's observations and the reasons for the traffic stop. Compliance with procedures. Whether the procedures followed during the arrest and testing were in accordance with legal requirements. This includes the administration of field sobriety tests, breathalyzer tests, and the handling of any chemical tests, blood, breath, urine. Implied consent. Whether you were informed of and complied with Missouri's implied consent laws, which require drivers to submit to chemical testing if lawfully arrested for a DUI, DWI. The administrative hearing is typically less formal than a criminal trial and may be conducted in person, over the phone, or through written submissions. During the hearing, you and your DUI, DWI defense attorney will have the opportunity to present evidence, cross-examine witnesses, such as the arresting officer, and make arguments against the suspension or revocation of your license. The hearing officer will then make a determination based on the evidence and arguments presented. Why is requesting an administrative hearing important? The administrative hearing directly determines whether you will retain your driving privileges. If you do not request this hearing, your license will be automatically suspended or revoked, regardless of the outcome of your criminal case. The suspension can significantly disrupt your daily life, affecting your ability to commute to work, attend school, and more. Missing the 15-day deadline means forfeiting your right to contest the suspension, leading to automatic penalties. By requesting and preparing for an administrative hearing, you offer your DUI, DWI lawyer an opportunity to present a robust defense, potentially leading to the reversal of the suspension and retention of your driving privileges, which can make a significant difference in the overall outcome of your case and help mitigate the broader impacts of a DUI, DWI arrest on your life. Importantly, the burden of proof in an administrative hearing is a preponderance of the evidence, which means the state only has to prove you were more likely than not to be intoxicated, rather than proving it beyond a reasonable doubt, as in your criminal case. Let's talk about how administrative hearings work in the state of Missouri. There are several steps to achieving the best possible outcome in your DUI, DWI license suspension case. 1. Receive the notice. Upon your arrest, you will receive a notice of suspension revocation from the arresting officer. This document informs you of the impending suspension or revocation of your driver's license and provides details on how to request a hearing. Carefully read and understand the information in the notice, including the deadlines and the procedure for requesting a hearing. 2. Submit a request. You must submit a written request for an administrative hearing to the Missouri Department of Revenue within 15 days of receiving the notice. This request can often be submitted by mail, fax, or online, depending on the specific instructions provided in your notice. If you had a valid Missouri driver's license, at the time of your request, you'll be given a temporary permit so you can drive until the hearing. Ensure that your request includes all required information, such as your name, driver's license number, date of arrest, and a statement requesting the hearing. 3. Prepare for the hearing. If you haven't already, the first thing you should do is hire an attorney. An attorney experienced in DUI, DWI cases can provide valuable guidance throughout the process, helping you understand your rights and develop a defense strategy. Your attorney will gather evidence for the case and can represent you at the hearing, presenting arguments on your behalf and cross-examining witnesses. 4. Attend the hearing. Your attorney will articulate your defense and emphasize any procedural errors or issues with the evidence. Your attorney may cross-examine the arresting officer or emphasize any procedural errors with sobriety tests. Potential outcomes of a DWI administrative hearing in Missouri. The outcome of an administrative hearing can significantly impact your driving privileges and overall legal standing following a DUI/DWI arrest. Here are the possible outcomes you might face. 1. Suspension upheld. If the hearing officer finds sufficient evidence to support the suspension, such as probable cause for the traffic stop, valid test results indicating impairment, or adherence to legal procedures, your license suspension will be upheld. The length of the suspension can vary based on whether it is a first-time offense or if there are prior DWI/DUI convictions. For a first offense, the suspension may last 30 days, followed by a 60-day restricted driving period. For subsequent offenses, the suspension period can be longer and may involve stricter conditions. Second suspension reversed. If the hearing officer finds that the evidence against you is insufficient, that there were procedural errors, or that your rights were violated during the arrest and testing process, the suspension of your license may be reversed. This decision would allow you to retain your driving privileges without any interruption. 3. Limited driving privileges. In some cases, even if the suspension is upheld, you may be granted limited driving privileges, allowing you to drive under specific conditions such as to and from work, school, or other essential activities. Obtaining limited driving privileges typically involves meeting certain requirements, such as installing an ignition interlock device, IID, on your vehicle, completing an alcohol education program, or demonstrating a specific need for driving. What are the consequences of not requesting an administrative hearing? Failing to request an administrative hearing after a DUI/DWI arrest in Missouri can lead to several significant and far-reaching consequences. Here's an overview of what can happen if you miss the 15-day window to request a hearing. Automatic suspension or revocation. Without a request for an administrative hearing, your driver's license will be automatically suspended or revoked. This suspension is triggered by the Missouri Department of Revenue and is independent of the outcome of your criminal case. Impact on daily life. Losing your driving privileges can severely impact your ability to commute to work, especially if public transportation is not a viable option. This can lead to job loss or decreased income if you are unable to fulfill your work responsibilities. Inability to drive can also affect your ability to attend school, transport family members, and handle daily responsibilities. Without a license, you may become dependent on others for transportation, which can strain relationships and limit your independence. Increased penalties. Reinstating your license after the suspension period involves various fees, including reinstatement fees, higher insurance premiums, and costs associated with mandatory alcohol education or treatment programs. A suspended license will likely lead to increased auto insurance premiums, as insurance companies view drivers with suspensions as higher risk. Permanent record. The suspension or revocation of your license becomes part of your driving record, which can have long-term implications for your insurance rates and legal standing in future traffic or criminal cases. By acting promptly and seeking experienced legal counsel, you can effectively navigate the administrative hearing process and defend your driving privileges, The outcomes of an administrative hearing can vary widely based on the specifics of your case and the quality of your defense. The best thing you can do for yourself is hire a defense attorney experienced in DUI, DWI, and license suspension cases to defend your interests. Chapter 8. Posting about the case on social media. Although social media has essentially become a dumping ground for the trials and tribulations of our daily lives, posting about your DWI or DUI case anywhere online can have serious and far-reaching consequences. We consistently share updates about our personal lives, jobs, families, opinions, and even seemingly trivial legal matters without a second thought, like getting a parking ticket 5 minutes after the meter expired or a speeding ticket for going 3 miles per hour over the limit. If you're facing DWI or DUI charges, the experienced Waterkotte criminal defense attorneys suggest you stop posting anything online. Everyone from attorneys and law firm staff to investigators and judges can access and scrutinize social media posts and pages to find potential impeachment materials. Simply put, anything you post on social media can be used against you. Here's why you should avoid discussing your DWI/DUI case online. Don't make the mistake of posting about the case on social media. Here's what our DWI/DUI attorneys say you avoid by not posting. Risk of self-incrimination. Anything you post online can be used against you in court. Even what you consider an innocent post or comment can be taken out of context and used to build a case against you. For example, a seemingly harmless photo of you drinking a beer in your backyard after cutting the grass could be used to suggest a pattern of behavior that might very well negatively impact your defense. Privacy concerns. Once something is posted online, it's nearly impossible to control who sees it and how it is used. Even if your social media accounts are set to private, there's always a risk that your posts can be shared, screenshotted, or accessed by anyone. This can lead to widespread dissemination of information you meant to keep private. Impact on public perception. Public perception can absolutely influence the outcome of your case, particularly if your DWI/DUI charges garnered media attention. Negative comments or posts can sway public opinion and possibly impact the general attitudes of judges or jurors. It's best to lay low and avoid adding fuel to the fire through social media activity. Compromising your defense strategy. Your DWI/DUI lawyers should work hard on your behalf to build a strong defense. If you're posting away on social media, you may inadvertently reveal details about your defense strategy or share information that contradicts what you've told your lawyer. It's happened before. Many times, unfortunately. This severely undermines your attorney's efforts and weakens your position in court. Employment and personal repercussions. Many employers monitor their employees' social media activities. Posting about your DWI/DUI case could jeopardize your current job and/or future employment opportunities. Also, friends, family, and colleagues may view you differently, leading to strained personal and professional relationships. How to protect yourself online. Following DWI/DUI charges. Social media posts can seriously damage your DWI/DUI case. Here's how to protect yourself. Avoid posting anything about your case. This is the safest course of action. In fact, it may be best to refrain from using social media at all until your case is over. Don't delete existing posts or accounts. Do not clean up or delete any posts or accounts. This could be considered spoliation of evidence. Inform your family and friends. Be sure that your friends and family don't post or comment on your case. Their posts may also be monitored and used as evidence against you. Consult your DWI attorney. Before posting anything online, consult with your Waterkotte defense lawyer. We can provide guidance on what is safe to share, and what should be kept private for the sake of your case. We hope that you have enjoyed this audiobook detailing how to handle a DWI or DUI traffic stop. We have a multitude of resources on our website and also on our YouTube channel. If you, or someone you know, has been charged with a DWI in the state of Missouri, contact the expert DWI attorneys at Waterkotte. Our attorneys are available 24/7 by calling 314-900-HELP in St. Louis or by calling 913-77-CRIME in Kansas City. We look forward to helping you in your time of need.